Calabrese versus City of Albany.
May it please the court, Robert McGee on behalf of Marisa Franchini, Corporation Counsel for the appellant City of Albany. If I may, I'd request 3 minutes for rebuttal.
Sure.
So the more key question before the court today really is whether an electronic communication can be a written communication for the purpose of a municipal
Counsel, before we get to that, I have a question. If in 2019 I saw a pothole on Lark Street and I wrote a letter and I took a picture and I mailed it to the Commissioner of General Services at the right address, would that be written notice under the statute?
Yes, it would. And to address the point, I mean.
And that would be written actual notice to the Commissioner, satisfy the statute?
It would.
And at that time, what would have happened to that letter?
It would have been, it would have been received by a city employee. They would have understood that by the Commissioner of Public Works, the person sending that communication meant it to go to the Commissioner of General Services, and it would have been sent to the Commissioner of General Services.
And then once it got into the building where the Commissioner of General Services is, what would have happened to it?
It would have been incorporated into the C-Click Fix system, or it would have been referred to the person in charge of making road repairs, and it would have been addressed.
And it's pretty clear that the Commissioner never reads any of this.
That's correct.
So what is the difference? Let's put aside written for a second in the email context. What's the difference between an electronic communication coming through SCF and going into that process and a letter going into the building and going into the exact same process, just in terms of actual notice, not, I understand, your written argument?
Yeah, in terms of actual notice, I think that would be a question to a jury whether or not that communication provided actual notice. But the fact of the matter here is that we have a prior written notice rule that needs to be complied with. And it's been
So
held.
you're not arguing to this court that it's the actual notice part wouldn't be satisfied. Your argument now is solely that this isn't a writing?
It's not a prior, yes, our argument is that it doesn't satisfy the City of Albany's prior written notice rule.
But because it's not in writing or because it's not actual notice to the Commissioner?
Because it's not in writing.
Okay, thank you.
And so the court has already answered
Just to clarify, this seemed to me, when you were answering, you answered without pause, that if the written letter is addressed to the Commissioner, whether the Commissioner reads it or not, it's notice within the meaning of the statute, right? If the letter does not have the Commissioner's name on it, but otherwise is directed clearly to the appropriate administrative entity, is the correct address, is that written notice?
there's an interpretation of actually given that would find that would be actual notice. And I think in those sorts of or prior written notice rather, and in those sorts of situations, I think the indicia under which the communication can be said to have been sent to the statutory designee would be directly proportional to its prior written notice effect.
So if I had sent the letter to the Commissioner of Public Works instead of the Commissioner of General Services, it would have still gotten to the right place?
It would have gotten to the right place. And I think under those
And that would be prior notice?
That's correct.
No, but my point was, there is no designee listed or put on the envelope. It is only the name of the entity and the address. You're saying that's prior written notice?
Not necessarily. I think, though, on those facts alone, I don't believe it would be.
Because?
There's, excuse me?
Because
there's no indication that that communication was meant for the statutory designee as opposed to an employee of the city, other than the statutory designee.
So it would have to be addressed to the commissioner, even if it was addressed to the department and mailed to the right department, the same department, but it didn't have the commissioner's name on it, that wouldn't be actual notice.
Again, if
even if it's handled exactly the same when it comes through the door?
well, assuming we have a writing,
Okay.
Right.
right? And then
Understood.
we've satisfied that portion of the prior written notice rule. Then you're moving over to the actually given. And what the city is asking this court to do is have the prior written notice rule enforced as written. And to answer this question of whether a given written communication, once communicated to the city, was prior written notice, is going to depend on whether or not, under those circumstances, it can be said that that communication was actually given to the statutory designee. And that would be,
actually given or actually sent to?
The prior written notice rule requires actually given. But under this hypothetical where we have the writing, you would look to things like who was it addressed to, what department was it sent to, what ways, how has the city instructed the public on how to submit prior written notice?
Does that designee have to accept and/or read its own mail?
By enforcing the prior written notice rule as written, that question more or less becomes irrelevant. I
No,
mean,
but with respect to a designee, when you have a designee, must they be required to actually accept that written notice? Or can they give that duty off to someone else and it still qualifies as as to the satisfying the notice requirement?
it's the city's position that the prior written notice effect of a given written communication is conferred on that communication by the person giving it to the city. And once they hand it over to the city, it becomes prior written notice.
So
regardless.
just the city, it doesn't have to be the designee?
Again, if you would look at the facts of that transfer, of that actual communication, and if the facts were that, you can conclude that that communication was meant for the statutory designee, then you satisfy the actually, you could satisfy the actually.
Let me ask you about this written. See click fix notifications arguably are written in the sense that they are expressed in words or letters. How are they not written notice?
Well, written and electronic communications they are treated differently, and they're treated differently in the case law. They're treated different socially. If I send you a birthday
Well,
card.
don't you write an
No.
email to people? You've never written emails?
The act of writing is what you do to create an email, but a writing
It's
is
a
a writing.
written communication if you're writing it.
Well, a written communication, it's a physical totem. It's something that is given from one person.
Doesn't that confuse the way in which we're communicating with the way in which we're transmitting? I mean, isn't the distinction between oral and written something that would put an email and a written letter together and a phone call in a different bucket? But if we're asking about transmission, then a written letter and an email would be in different buckets. So why wouldn't writing encompass both an email and a letter?
Because, when you're looking at a prior written notice rule, as Judge Kay held in the Fermarelli case, or noted in the Fermarelli case, is the court its purpose, its lodestar is to effectuate the purpose of the legislature in that case. And you look at the text, and the text of Albany's prior written notice rule, most prior written notice rules, requires a writing.
But they could say, has to be put in the mail, has to be written on, with pen and paper, has to be, certified mail, whatever. But how do we know that they mean to exclude emails, given the common parlance with which we refer to writing emails?
Well, in Gorman, this court held that a written notice was exclusive of a telephonic note, or
But that would
telephonic
be the
notice
oral
writing.
written distinction.
And doesn't
If
that seem to
there's-
make some sense? That is, oral, you don't really have a record of it, so then there's going to be a battle about did you call, was there a call, what was said on the call, but you don't have that problem with an email communication or through see, click, fix. There's no dispute about the content, right? Where the oral, they're clear, and there's even a dispute about whether it happened.
That is true, but I'm not sure it's relevant to the inquiry, because
Well,
we're
why isn't
looking at.
that the purpose? Why isn't that the purpose of the written notice?
The purpose of written notice is to manage a municipality's liability for road defects.
Right, and so
if-
that when somebody, it's so that when somebody sues, you know whether you have been notified about it before or not. And with an oral communication, there is maybe not a record of that.
I respectfully disagree. I think it is, the purpose of a prior written notice rule is to open up to the public an opportunity to open up the public fisc. for
When was
tort
it
li-
enacted? What year?
This version of the prior written notice rule was enacted in
Well, that's-
1983, but prior written
I'm
notice.
sorry,
was
what year?
1983.
Okay, was
But
everybody using emails in 1983?
They were using fax machines, and telegraphs have been around for a long
Were
time.
those considered written notice?
I don't believe so. And in Gorman, according to Gorman, no.
Wait, so a fax to the commissioner back then would not have counted? Comes out in paper.
Well, telephonic communication reduced to
I'm a
writing is not.
Fax.
I guess a fax, I think under Gorman.
Because
Yeah,
it's a telephonic communication, but is then reduced to writing? Is that why? Because it wasn't originated in writing? Is that your point?
Well, yeah, I mean, so if The city is, if the party to be bound is generating that writing, I don't think it can be said that that writing was given to the municipality.
But
They
what
can't-
about like the net effect of it? What's the difference between how it's documented, processed, tracked, if it came in written notice or if it came in through C-Click? Is there any difference in how those reports are handled?
There's no difference within the city, but again, these written communications may qualify
Okay,
for.
so there's no
as writing.
difference in how it's handled, tracked, documented. We know that the commissioner doesn't read it. So ultimately, aren't we just elevating form over substance here?
No. So
Why?
a prior written notice rule is, again, it's meant to manage the city's, it's supposed to put a city on notice as to when it has legal liability for a given defect.
Well,
So if
wait,
there's
why,
an-
why doesn't an email do that? It may be that your view reduces liability, but why doesn't it advise the city of liability?
Well, we're not talking about, in this case, we're not talking about emails, we're talking about electronic communications. And electronic communications take.
Sorry, what's the difference between email and electronic communication?
Well, a C-click fix in this case is not an email. An email, someone has an inbox and you intend to send it to a particular inbox. With a C-click fix, again, we're talking about, almost like a social media type platform.
I thought
where
that you use C-Click Fix to identify locations that needed some attention.
It is.
Okay, and so there's some intake process presumably in which what comes across the transom is documented. Because otherwise it would be impossible to,
Right.
issue a work order.
But again,
So how would I do that? If I see a pothole and I want to use C-Click Fix, how do I enter the information?
there's an app in your phone, or you can go on, you can do it through a website.
And a screen comes up, and I type the information into that screen, and then what do I do with the screen? How does it get transmitted?
So it is sent to a central location within the
But I
city.
hit send
Yeah,
somehow.
so
So what is the difference between that and an email? I write it on a screen and I hit send.
there's not a huge difference, but there is a large gap between an email and a writing. And that's
Can I
the
ask you,
key
could the
distinction.
city amend its prior written notice statute if its preference, understanding that technology's changed a lot in the past, I guess 40 years, right? If the city wanted to exclude either information received through an app or even an email, could it amend the prior written notice statute to say only, letter sent via, you could pick what you want, certified mail, or whatever it is, constitutes prior written notice for purposes of liability?
It could do that, but it shouldn't have to, because written is unambiguous. And the purpose of the prior written notice rule is to define the precise instance in which someone can put.
Okay, so we got, I think, I understand your argument on that, but what about this designee? Because I'm still not clear, even with something that's, from your position, indisputably a writing, right? The written, the paper, the envelope, commissioner's name, the address, you agree that's written notice. The envelope that doesn't have the commissioner's name, I think you said before, it depends.
Yes.
When would that be written notice if the commissioner's name is not on it? Which just a sidebar, I don't want to lose this moment on this question. On this platform that they can use, can you direct it to the commissioner? Or you don't even have that option?
That is not a default option.
Okay, that's all I needed to know. All right, so now, again, the envelope of the letter that doesn't have the commissioner's name but does have the correct entity, when is that not notice? Or when is it notice? You choose how you want to answer.
A prior written notice rule, one of its purposes is to allow the city to speak candidly with the
Yes.
public about defects without
Okay.
incurring that kind of liability. So to look at that, again, we're looking at it in DISHA within that circumstance
Yes,
of the recipients having intended that communication for the statutory designee.
I'm
And that's a
sorry.
question the court doesn't.
I thought it was a yes/no answer. I'm getting very confused. I get when the commissioner's name on it, you agree that that is notice. I've just changed one thing, the commissioner's name is not on it. Isn't that just a yes/no? Yes, it's written notice, no, it's not.
No, but I
No,
think
it's
there
not.
are, but again, there are still facts wherein that could be considered prior written notice. But
Give me one example, just one.
if there's a prior written notice box at the statutory designee's office, and he says,
And that's where you put it.
right,
Because then one would infer, if I put it in the box that's going to the designee, then the fact that I didn't put their name is irrelevant because it must be going to them.
Exactly.
Okay, but if otherwise I just put it in the mail,
Right.
that sounds like you're saying no. Okay, one more. Same envelope, doesn't have the commissioner's name on it, but when you open it, it says, "Dearest Commissioner." Is that notice?
I think it could be prior written notice, yes.
What's the could be in that, as opposed to it is
Well,
or is not?
if you were to put that envelope, it depends on where you delivered the envelope. I mean, but if you delivered it to the office where the statutory.
Yes, it's the same as the second one. It just has the correct address. Let's say the designee is actually in the same building with,
Yeah.
with the agency itself. But the inside is where I've put "Dearest Commissioner."
Yes, that would be prior written notice. But the
But
court
let's
is not.
say you did that on your screen, putting the writing aside, you put "Dear Commissioner" on the screen and hit send through C-Click Fix. Would that-
If the city of Albany's prior written notice rule allowed.
Yeah,
writ-
putting
communica-
aside the
Right.
written, yeah.
That would indicate that it was prior written notice.
Well, aren't you able to put text in, or no? You can't put
can.
text, you're just choosing things?
Yes, well, right, in a C-click fix, you're asked to provide a narrative of
Yes,
what
so,
you've seen,
yeah,
and you could include in
put
that.
"Dear Commissioner."
But after the commissioner gets notice, assuming it was addressed correctly and so on, don't you initiate a work order through this process, the C-click process?
Right, you do, yes, that.
Right, so all of those notices get translated back to the thing that you're saying doesn't give notice. There's no other mechanism, right, by which to address those. It's not like you're going to get a letter to the commissioner, correctly addressed, and then it's given directly to a worker and said, go out and fix this. No, you take it, right? Albany has set up this system where you take that letter and then put it into C-click, correct?
Right, but we're not arguing that if we received a written communication and then put it into C-click fix, it would no longer be prior written notice.
You're not arguing that?
No.
I thought you, in a response to a question Judge Singas asked you a little while ago, that putting the information into C-Click Fix is not the same thing as getting the information via a writing.
So the C-click fix is used, and I see I have my lights on, but.
Yep, go ahead, please.
So C-click fix is used as a way for the city to manage its work, as well as a means by which the public can communicate with the city. And whenever the city receives, whenever the people at DGS receive communication about a road defect, whether it's by phone, in-person, email, from another city employee, they will then put that into C-click fix, and then we'll process it that way. But we don't concede that converts any such communication into a writing, because, the court below didn't find that, because it was a work order, it could be
So
prior.
it's notice, but not a writing? Is that what you're saying?
It doesn't, so, yeah, City of Albany's prior written notice rule requires written notice.
No,
and
but I'm
it's
saying,
not a writing.
putting it in C-click fix is notice, but it's not a writing. Is that what you're saying?
It's notice, but it's not sufficient to,
Because it's not a writing.
right. So
But are you
couldn't
also claiming, I guess going back to my original question, are you also claiming that it isn't actually given to the commissioner unless it says "Dear Commissioner" on the screen?
Yes, but again, there's no evidence whatsoever on the record that the commissioner received the C-click fixes at issue in this case.
No, I'm not saying, there's no evidence he received anything, but apparently never receives anything. But if I send a C-click fix written, I type it on my screen, again, putting aside the writing issue, and I send it through this process, and it's processed the way it's described in the record, is it, again, putting aside written, is it actual notice given to the commissioner? Or do I have to put "Dear Commissioner" in that screen? Or is it okay if it just goes to the right department?
Again, we don't have a writing, and I think that might be getting lost. In terms of whether it's actually given, that would indicate that it was that electronic communication was actually given to the statutory designee, but that wouldn't be sufficient to satisfy the prior written notice rule or to maintain a road defect liability case against the City of Albany. I mean, ultimately, we're just asking for the prior written notice rule to be enforced or applied as it is written.
Thank you.
Good afternoon. May it please the court. My name is Peter Blauskis with Harding Mazzotti for the plaintiff respondent Henry Calabrese in this case. There are a number of questions that need to be addressed on this appeal. Firstly, in my view, the question is whether see-click-fix notifications constitute a writing under the appellant's prior written notice statute in this case. And it is a fundamental rule of law that the clearest indicator of the legislative intent is to look at the statutory text.
Why is that question relevant if I understand your adversary's argument correctly? The statute requires prior written notice, and that is a legal term of art, apparently, that signifies a very particular thing, which is basically words written in ink or pencil on a piece of paper and delivered to a physical office somewhere. If it's a writing, that my understanding of his argument is that that's a distinction without a difference,
Well,
or it's a distinction with a huge difference.
well, the way the prior written notice statute in this case reads is written notice. And written notice, given its plain meaning, simply means forming visible letters or characters. That's according to Merriam-Webster.
So if they understand it to mean one thing, but we collectively, as people who read statutes and interpret them, understand it to mean something else, our view of what it is prevails? Is that your
The
argument?
plain meaning prevails.
So if we think written is something you submit on SCR, or something you mail, maybe even something you email, you're good.
Correct. That would be correct, Your
I
Honor.
think as
Does
Judge
it
Ru-
matter when it's enacted, you don't have this form of communication?
It doesn't matter that this specific technology did not exist. The definition of a writing would be putting words or letters together so that you can visualize
What
them.
about the argument that it's a legal term of art of what a writing is?
Well, that is not the way that a statute is interpreted.
Well, so what if I send it in a Snapchat that disappears automatically after somebody opens it and reads it? Written, not written?
Well, if you've typed it,
Yeah.
it is a writing. And what I would say to that.
Sorry, so that's a yes, that
Yes.
satisfies the statute?
That satisfies,
Don't you think part of the purpose of this is so that the city has something in the form of a permanent record, so it knows what it has received before, and a Snapchat would not fulfill that purpose?
well, I would assume if you were using a Snapchat, there would be some way in which to make a permanent record of that once it has been received.
Well, what if there wasn't?
Well, then I would say if it hasn't constituted a written record, then it is not written notice. In this case,
So it doesn't matter if you wrote it originally, it has to be preservable in written form?
well, I would imagine that Snapchat, even when received, is somehow recordable at that point where you receive it. It can be made, a copy can be made in some form or fashion. What is important is, what does it mean to be written? And
Let's assume we agree with you on that. Isn't the real problem that it's got to be written and given to the designee? And unless any of these things say, "Dear Commissioner," perhaps they don't satisfy that part of the requirement.
correct. Well, I would disagree that it would have to say, "Dear Commissioner." In a case where it is actually given, in this case, there is no dispute that the see-click-fix notifications were actually made and actually received by the Department of General Services.
But that doesn't mean that the designee got them. That was my point about, here's a letter, doesn't have the designee's name on it. You open it up, still doesn't have the designee's name on it, but it sets forth some grievance and it goes through the normal course of that
Correct.
administrative entity.
Correct. But if you look at the record in this case, the statutory designee is telling the public, send see-click-fix that notification to my office, to me, to this location.
Well, they're actually
see-click-fix.
saying, though, that that isn't notice under the statute in the system, right? They're saying this doesn't constitute notice. Isn't there some kind of disclaimer on the system?
They are trying to say that, and to which I would say that you, as a legislative body, have written a statute. It is the statute which controls whether or not prior written notice has been satisfied.
So on that front, I think we generally look not only at the text of the statute, but also at what the purpose of a provision was. And I think we can agree, unless you were perhaps, working way ahead of your time, that in 1983, that people were not using email. And so it seems likely to me, maybe certain almost, that the intent behind the words prior written notice was a mailing. Not necessarily maybe through the post office, you could maybe drop the letter off, but it would be a handwritten letter. You agree with that?
Well, I would agree with that, except for the time frame that we're talking about. In 1998 is when they are saying that their prior written notice allegedly was modified to now include the Commissioner of General Services.
Okay, but I thought that it was originally enacted, I thought your adversary said about 40 years ago. My question is just that if it seems clear to us, just as a matter of technology, that what was contemplated at the time was a piece of paper with some ink on it, why shouldn't we hew to that and exclude email and honor the purpose of the provision?
Because they have the ability to update their statute to keep
Sure,
up with
but
the
in terms of
times.
understanding what those words meant, if it seems clear to us that they couldn't have intended it to include email because there was no email, why wouldn't we read it that way?
Well, again,
And then they don't update it.
I'm
They
sorry.
don't update it,
Well,
right? I mean, that various governmental entities have updated whatever applies to them in terms of the way they communicate, both internally and with the public.
correct.
If they don't update it, aren't we then left with the understanding that they still mean this thing right here?
Or what they meant was words or characters that are capable of being read and made into a written record, which is what an email would be, which is what C-clicks would be, which is what a letter is. They receive it, they have a written record of having received it and having been put on notice.
So they send it in hieroglyphs, that's okay?
I wouldn't say if it's in hieroglyphs, Your Honor, but I would say if they have been put on notice, and there's no dispute that this was in English, that these C-click fix were put in English letters.
And does it matter that they set up C-Click Fix and invited the public to provide information, and that information goes through the system to reach the people who are responsible for actually responding? Does that all play into your interpretation?
It absolutely matters. They intended to have this
Yeah,
system.
but it completely bypasses the designee, doesn't it not? All the designee gets is some spreadsheet.
Correct, but there is no requirement, there is no precedent that the designee actually views it or reads it. It is that he's actually given it. In this case, he is in possession and control of that. He has implemented a system where he is bypassed.
Right, a system that I don't see it, but you can submit all the grievances you want, and maybe my agency can get to them, maybe they won't, they'll prioritize it. If you want it to come to me, put my name on it, put it in writing, and send it to me.
No, that is not the record in this case. Nothing reached this commissioner, whether you put it in writing, in an envelope. He delegated his mail to his deputy commissioner. That was also bypassed through the commissioner. The commissioner never saw any writing in any form of any kind in this case.
Counsel, just to pick up on that point, when a written communication came in and it went to the deputy commissioner, then what would happen to it?
Then it would get assigned to a supervisor, and it would also be put to a clerk at the front desk who would then input it into C-Click Fix, because C-Click Fix was incorporated as the only form of work orders used by the Department of General Services. They used it as their work orders. They also acknowledge that it is the only form of record that they keep. It's
So
C-Click
if it
Fix.
came in originally through C-Click Fix, the only thing that would be different from what you've just described, the process being with respect to a letter, would be it wouldn't go through the supervisor step to, the deputy supervisor on down, it would just go into the C-click fix level.
So the C-click fix, as the record is, it goes to the front desk clerk of the Department of General Services.
So if it's writing, it comes down to the clerk through the deputy commissioner through a supervisor then, to the same place?
Correct, correct. And
I just want to double check on that very same issue because I think your adversary sort of intimated that C-click fix is the general portal, but there was different treatment depending on how they received it or possibly what it was for. So are you saying whether it comes in as writing, a writing maybe that even mentions the written notice law versus something that's submitted by someone who just happens to see something and goes on C-click fix, it's treated exactly the same? The same steps happen once it's received, except for the added step of transcribing it into C-click fix.
correct. That is correct. And they both bypass the statutory designee. He
Yeah,
never
no,
sees
no, yeah, I'm not as concerned about, I know, you have a lot of questions about dear commissioner or naming the commissioner. That's not my question. My question is whether these things are treated differentially, if it can be determined that one is for purposes of providing notice, it's just a very conscientious citizen who's writing as the notice law provides to let Albany know there's an issue, versus someone who's trying to get something fixed. Are they treated the same?
They're treated the same by the city. The same procedure is followed. One comes in through a C-click notification to the Department of General Services, to the front desk, who then assigns it to a supervisor. A letter would be handled by the commissioner's deputy, who would then give that letter to the front desk, who would do the same process.
And then it goes in, and a repair order is generated, and that goes to whoever it's supposed to go to, and maybe there's a repair, and maybe there's not a repair, but the treatment is exactly the same.
Treatment is the same.
Counsel, there's some indication in the record that some of the C-click fix notices were originally telephonic. Is that your understanding?
That is true, and we're not making the argument that a telephonic communication that is converted to writing would satisfy the prior written notice statute. We're talking strictly about the ones that are typed in and which are capable of being read at that point, just like a letter would be and would satisfy any form of written notice. It's just a different form of written notice. And as was raised initially, the appellant and the municipalities in this case have the ability to control their statutes. They can write the statutes the way they want, and they can restrict them in the way they want. They could easily have written, handwritten, or they could have easily written made by registered mail. That was not done in this case. The words written notice are the only words on that. And they are seeking to place a restriction now on this appeal that is not included in that statute. Again, the commissioner put into place and promoted C-click fix as the way to reach him. That was what the citizens were following, and it was a writing, and it does qualify. I also want to briefly touch on the fact that at the time that this accident occurs, the prior written notice statute had the statutory designee as the Commissioner of Public Works. That is a position that had not existed for 20 years in the city of Albany. The Commissioner of General Services, in a completely different section of the code, was to adopt or pick up the responsibilities of the Commissioner of Public Works. However, anybody who was reading the prior written notice statute.
So your position under that, which I understand to be an impossibility argument, would be that for 20 years, there's no necessity for anyone to show notice was given?
Well, it's in two parts. That is part of it. The other part of it is, how can the city demonstrate prima facie that the Commissioner of Public Works did not get written notice in this
Is there ever an
case.
instance where they claimed a lack of notice because it didn't go to the non-existent person?
Well, I don't know if they ever claimed it, but for them to meet their burden to show there was no prior written notice under their statute as written at the time of this accident, they would need to show that the Commissioner of Public Works never received written notice before this accident. I don't know, and there's nothing in the record to show how that is possible, how they can show that somebody
The
didn't
effect
send a
of
letter.
that, to go back to my question, would be for 20 years, there was no requirement that you give prior written notice.
That would be correct. That would be the end result of that, Your Honor. They could not make out that prima facie on a motion with respect to their burden. The last point, and I know my time is running short, is there is also obviously an exception to the prior written notice requirement, and that is with respect to the affirmative negligence that creates an immediate dangerous condition in this case. What we know is that on April 3rd of 2019, the city's water department did a hugely extensive dig right at 67 Lark Street. They opened up the entire roadway. We know that they filled that roadway back in, and that as early as the next month in May, there was a C-Click Fix phone call made and said, hey, there's a giant hole in the area of 65 Lark Street. Now, these houses are very close together, and it is rattling the entire roadway. Can somebody please go take a look at that?
Do you think I assume you're going to conclude with the position that you're entitled to summary judgment on this create theory? Is that right?
No, I'm saying there is at least a question of fact
Oh,
there
okay.
that gets through the prior written notice as an exception. Because we know that as in June, that there's an internal email from the water department that says, the roadway is sinking, please go out there and investigate. Now, we know that in July, this accident happens where Mr. Calabrese hits a large depression in the roadway.
Have the courts below, either of the courts below, deprived you of your opportunity to show that the defect was created by the city?
No, Your Honor, they haven't deprived us of that. My understanding is on this appeal, part of what they are arguing is there is no an affirmative creation argument available. I'm saying that there is, and it is applicable to this case, separate and apart from the prior written notice statute. We put in an expert who explains that this is not something that gradually happens over time where you have all these notices so soon after a giant dig. This is something that was immediate, and this was a problem immediately. He uses that term directly following the dig. This was a bit apparent. This is not something that happened with delay when you have this many notices in sequence. So in addition to the prior written notice statute, we would ask that this court affirm below on that basis.
Thank you.
Thank you.
So,
Could you address why the C-Clicks posts are not covered? 'Cause I think this is your position, are not written notices covered under the Electronic Signatures and Records Act?
well, I mean, state technology law 309 says very explicitly that nothing in the ESRA requires a governmental entity to use electronic records. ESRA is instead a way for government or business to use electronic records and rely on them as if they were written according to the prescribed.
But Albany does use electronic records, does it not?
Not for prior written notice, Your Honor.
Is that because of your disclaimer?
That's because of the way the prior written notice rule is written. So the prior written notice rule is a means by which a member of the public can, on their own, open up the public fisc to tort liability for a given road defect. And the Albany's prior written notice law prescribes a way in which that is to be done.
What do you say to the suggestion that for 20 years, you really had no notice statute because there was no real designee?
Well, there was a designee. Again, if you get to that second element of our statutory construction principles, the purpose, if you look at when the city code was amended, it was clear that the Department of General Services, their commissioner was going to stand in as a statutory designee. And that's how it worked in numerous cases and for that time, including a case that's come before this court. In all those cases, the prior written notice rule in Albany was found to be functioning properly.
You've
about the
changed
vet-
that rule, right? You've changed the designee now, right? You amended the statute. You
Yes,
made no other changes to the statute, though, at that time?
No, just that. And I should note, though, that when that change was made, there was no incorporation of C-click-fix into that, because again, written communications and electronic communications are different. And I would ask the court.
Albany set up the system in this way, right? They could have set up the system the way other municipalities have and treated C-click as like a 311, right? And that wouldn't have constituted notice. But Albany decided to make it part of their operating procedure, and the only way to track and keep track of and issue work orders. They made it part of their system of government very systemically. So how do you answer that? I mean, there was a choice that Albany made, and now it seems that you made that choice, and now you're backing away from it, saying, oh, no, that's not notice.
When it came to communicating with the public, C-click-fix did operate like a 311 system. The city's contracting for this service, and what it allows us to do is more systematically track, and I see my time's up, but I'll answer, more systematically track their receipt of communications about road defect, regardless of where they came from, and how they respond to it. It's a matter of good government. It's a way of memorializing what we receive when, to make ourselves accountable to the public. But we never amended the prior written notice rule to require, or to allow for anything other than written notice that was actually given to the commissioner to create that liability on the part of the public. And looking at the purpose of a prior written notice rule, if the court is going to adopt the reasoning of the third department, it's going to have to essentially find that electronic and written communications are fundamentally the same. And that's not something that's borne out in the case law. I'll refer to Misty Cleaning Services. It's not something that's borne out in common sense. If you received a birthday card, it means more than a birthday text, just as an example. So as the court's writing its decision in this case, it needs to think very seriously about whether or not written still means something in the context of a statute that allows one party to impose a legal obligation onto another. Thank you.
Thank you.